Hello guys, welcome to Ideal Bibliotheca. Today's topic is over Lok Adalats. It's a very small topic and a part of subordinate courts. So let's start with it.
So today we need to see about Lok Adalats. Lok Adalats is a topic which is under subordinate courts. However, this is important because there has been a question in the UPSC regarding this, which we might be discussing this very Saturday. So, Lok Adalat is a forum where the cases which are pending in a court or at pre-litigation stage are compromised or settled in an amicable manner. So what is it? If there is a case between you and me, what we do is, instead of going to a court and getting a result either in my favor or your favor, we go to this Lok Adalat and we somehow compromise or settle our dispute in a way that yes, our friendly relations are kept and things don't go worse and somehow the dispute is settled. So let's know about the meaning. The Supreme Court has explained the meaning. What is it? It is an old form of adjudicating system which it prevailed in ancient India, has not been taken away even in the modern days. So the term Lok Adalat means people's court. The system is based on Gandhian principles. And how important is Gandhian principles? That we know when we see the DPSP chapter, because there is a separate Gandhian ideals there. So it is one of the components of alternative dispute resolution system, and as the Indian courts are overburdened with the backlog of cases and regular courts are to decide the cases involving a lengthy, expensive and tedious procedure, so the court takes years to settle even petty cases. So Lok Adalat provides alternative resolution, but here there are no victors and vanquished and thus no rancor. Why? Because they resolve everything in an amicable manner. So it is an alternative mode of dispute settlement, that is ADR here we saw, and this has come to be accepted in India as a viable, economic, efficient and informal. These are the advantages. And then Lok Adalat is another alternative in judicial justice, and thus this is a recent strategy because it delivers again this informal, cheap, expeditious, so it's economic also, to the common man by way of settling disputes which are pending in courts and also which have not yet reached courts by negotiation. So this Lok Adalat has got its statutory status. How? Because this first Lok Adalat camp in the post-independence era was organized in Gujarat in 1982. Initiative proved very successful, and thus institution was functioning as a voluntary and conciliatory agency but without any statutory backing. But since this wasn't having, it was given a statutory status under the Legal Services Authorities Act 1987. For people who do not know about statutory status is that if this is an institution and this has a statutory status, that means that its relevance is mentioned in some article or in some amendments that have been done, so that it's legally backed by the Constitution. So what are the provisions regarding this act? The first is that the State Legal Services Authority and District Legal Services Authority or Supreme Court Legal Services Authority or High Court or Taluk or may organize Lok Adalats at such interval of places for exercising jurisdiction as they think fit. So it's not that it has a forum or it has a platform, it can be organized anywhere where they desire. So every Lok Adalat organized for an area shall consist of such number of serving or retired judicial officers or other persons as may be specified by the agency organizing such Lok Adalat. And generally a Lok Adalat consists of a judicial officer as a chairman and a lawyer and a social worker as members. Then a Lok Adalat shall have jurisdiction to determine and to arrive at a compromise or settlement between the parties at any case pending before any court or any matter which is falling within the jurisdiction of any court and is not brought before such court. So they can deal with not only cases pending before a court but also disputes at pre-litigation stage. And what are the matters that can be dealt here? Matrimonial, family, criminal, land acquisition, labor, workmen's compensation, bank recovery, pension, housing board, slum clearance, housing relating to telephone bills, municipal matters, everything, every small little thing that can be finished here, we tend to finish it here. But the Lok Adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. So it's not that any laws can be fulfilled here or any laws can be discussed here. These laws cannot be. These acts, these things that are required to have a different and experienced action, that is not discussed here. And then any case pending before the court can be referred to the Lok Adalat for settlement if the parties agree, or one of the parties makes an application, or the court is satisfied that yes, matter is an appropriate one. And then Lok Adalat shall have the same powers vested by the civil court under the Code of Civil Procedure. And what are they? See, summoning, enforcing the attendance of any witness on oath, and discovery, production, deception of evidence on affidavits, requisitioning of any public record, and any matters that may be prescribed. And a Lok Adalat shall have the requisite powers to specify its own procedure. Also, all proceedings before a Lok Adalat shall be deemed to be judicial proceedings with the meaning of Indian Penal Code, and every Lok Adalat shall be deemed to be a civil code for the purpose of Code of Criminal Procedure. And then a word of Lok Adalat shall be deemed to be a decree of a civil court or any other court or any other order. Then benefits, there is no court fee, so economical again. And then if it's paid, then it's refunded. Then basic features are procedural flexibility, speedy trials, at least speedier than the courts, and then there is no strict application of procedural laws. So these are benefits. Benefits we also saw when we were doing here. Here we have viable, economic, efficient, and informal. Everything will range between these four. How? Let's see. See, no court fee, already we saw how economical it is. Then the basic features of procedural flexibility and speedy trial. So we can these are all viable. We can at least rely on them. And the parties to the dispute can directly interact with the judge through their counsel. So this is also there. And the award by the Lok Adalat is binding on the parties and has the status of a decree of a civil code that we saw here. Then Law Commission of India summarized the advantages of alternative dispute resolution: less expensive, less time consuming, free from technicalities, and then parties are free to discuss their differences of opinion because they get a forum to just discuss on the disputes, because anything that has to come up is to settle things in an amicable manner. Then parties have the feeling that there is no losing or winning side, because somehow they both are looked upon, they both are heard, and then a mutual decision is bounded. Then we have permanent Lok Adalats. What are they? Legal Services Authority, the act that backs that gives the statutory status to the Lok Adalat, it was amended in 2002, and it gave permanent Lok Adalats to deal with cases pertaining to the public utility services. What are the reasons? See, because this was enacted to constitute Legal Services Authority for providing free, competent legal services to the weaker sections of the society to ensure that opportunities for securing justice were not denied to them. Then system, which is an innovative mechanism for alternative dispute resolution, has proved effective for resolving disputes in a spirit of conciliation outside the courts. And then major drawback in the existing scheme of organization is that the system of Lok Adalats is mainly based on compromise or settlement. So this is one disadvantage, and this causes unnecessarily delay in the dispensation of justice. And so if Lok Adalats are given power to decide the cases on merits in case parties fail to arrive at any compromise, this problem can be tackled to a great extent. That is why there was something called permanent Lok Adalats. Then cases which arise in relation to the public utility need to be settled urgently. So for that, yes, permanent Lok Adalats is beneficial. And then it proposed to amend the Legal Services Authorities Act to set up a permanent Lok Adalat for providing compulsory pre-litigative mechanism for conciliation settlement of cases relating to public utility services. What are the features? Shall consist of a chairman, and the qualification is mentioned here. Then permanent Lok Adalat shall exercise jurisdiction in respect of one or more public utility services. Then the pecuniary jurisdiction of the permanent Lok Adalat shall be up to rupees 10 lakhs. Permanent Lok Adalat shall not have jurisdiction in respect of any matters relating to an offence not compoundable under any law. Before dispute is brought under any court, any party to the dispute can make an application to the permanent Lok Adalat for settlement, and then when it appears to the permanent Lok Adalat there exist elements of a settlement which may be acceptable to the parties, shall formulate the terms and accordingly go towards the agreement. Then every award made by the permanent Lok Adalat shall be final, binding on all parties, and shall be by a majority of the persons constituting the permanent Lok Adalats. Then we have two small portions which we'll do in later portions and later parts when those I feel that are important and somehow we can relate it with question and answers. This was it with Lok Adalat. I hope that you found it useful, purposeful. Let's meet soon in another video. Until then, take care. Thanks for watching.